Your judge messed up your trial. You file an appeal, and all of a sudden, at the first step, the Court of Appeals denied your claim. Can they really deny your claim without even hearing about all the mistakes that the judge made? Unfortunately, yes. So, let me explain to you some of the procedural steps that you can't mess up in the Court of Appeals. Today I want to break down a key distinction in Michigan appellate law, the difference between an appeal by right and an appeal by leave. And if you're considering challenging a court decision, it's essential to understand the difference. I'm Jim Kraayeveld, and for the last 3 decades, my team and I have successfully represented many clients before the Court of Appeals. Filing an appeal with the Court of Appeals is no picnic. It's complicated. The demands are high, and you really can't mess it up. Because if you had to file an appeal by leave and you tried to file it as an appeal by right, you may have an issue. So let me discuss an appeal by right. An appeal by right gives you the automatic right to appellate review, and it applies to final orders regarding judgment of divorce, final custody orders, domicile orders that are often post-judgment. So anything regarding a full trial, custody, domicile. But there's a deadline of 21 days from the entry of the judgment or the entry of the order. You don't have to ask for permission on that. Other decisions, though, are only allowed to be filed as an appeal by leave. It's not automatic. So you have to first file an application for leave to appeal. It's like saying, may I have permission to appeal? And the court has the discretion to accept or deny that. That right applies to any non-final order, and it can also apply to changes in child support, any amendments to the judgment of divorce that aren't regarding custody or domicile, usually financial issues, are all going to require leave. It has like a higher burden with the application for leave because you have to show that the decision made by the judge is significant. And the risk that you have is that the Court of Appeals may simply decline to hear the case, thinking you haven't stated a big enough reason why they should spend their time even listening to your request to actually file the appeal. So, big differences. Right versus permission. Right, it's guaranteed. Leave, it's discretionary up to the Court of Appeals. And as I mentioned, it all depends on the type of order that you're appealing. Final orders, custody orders, domicile orders are all appealed by right. Orders that are amending a judgment or are dealing with smaller issues like child support or choice of realtor or whatnot are all appealed by leave. The risk is that, yes, an appeal by right guarantees review, but you gotta have the right subject matter to have that right. And an appeal by leave might not even be granted. So, if you're going to pursue a claim by right, you have to file your claim of appeal on time. If you're going to be appealing by leave, you have to file your application for leave, but include your arguments, your documents, and have a pretty good idea of what it is that you want to put in front of the Court of Appeals so that when they grant that application, you then can actually file a complete brief. Now, it's probably going to be very similar and have overlap because you have to have all of those issues right up front, which makes it like a 2-step process and more expensive. I want to at least give you like 2 examples of how this would apply. You have Christy and Peter and Emily and James. Peter has a child support decision in the final judgment that he wishes to appeal, and he can do so by right. If it were post-judgment, it would, and it's all on its own, it would not be by right. An issue that we have with Emily and James, they seek a post-judgment change in realtor, for example, and a realtor was ordered to list and sell their house. It doesn't happen. They go back to court. And one of the parties doesn't like the decision of the judge to say, well, you have to use a particular realtor. And James says, I want to appeal this. That is by leave, not by right. So, a couple of things I want to point out. Not all rulings are immediately appealable. Filing the wrong type of appeal risks it being dismissed And it can also risk being sanctioned, where you get fines and costs levied because you weren't filing the correct type. So, I've mentioned before in my different videos, appeals require more than just a dissatisfaction with the judge's ruling. You have to show legal error, and you have to show that the cost of the appeal is worth the correction. If a judge makes a $3,000 adding error, and on a motion for reconsideration you can't point that out and get it corrected at the trial court, it's probably not worth appealing. So even though you may have an appealable issue, it might not be worth it. But if you think you have reasons to appeal, you shouldn't be navigating appeals alone. You need to consult with a knowledgeable family law attorney who does appeals work. Winning an appeal without an attorney has a very low chance of success. Subscribe for more content and visit us on our website and contact us if you ever need any help. Until next time.